See the decline was the dogma, absolute power made by the hypothesis of a popular origin, hypothesis of a popular be as legitimate as constitutional freedom began to affect dogma that absolute power made. The hypothesis of a popular origin be as legitimate as constitutional freedom began to darken the air. Here in our discussion, we devoted more attention to develop developments in Germany. Earlier in our discussion, we devoted more attention than is usual to development in Germany, partly because it was in the country that the theory, if not the practice, of the rule of law was developed furthest, and partly because it was necessary to understand the reaction against it, which commands there. As true of so much of socialist doctrine, the legal theories which undermine the rule of law originated in Germany and spread there to the rest of the world. The interval between victory of liberalism and the turn towards socialism or a kind of welfare state was shorter in Germany than elsewhere. The institutions meant to secure the rule of law had scarcely been completed before a change in opinion prevented their serving the aims for which they had been created. Political circumstances and developments which were purely intellectual combined to accelerate a development which proceeded more slowly in other countries. The fact that the unification of the country had at last, been achieved by the artifice of statesmanship rather than by gradual evolution strengthens the belief that should remodel society according to a preconceived pattern. The social and political ambition which this innovation encouraged were strongly supported by philosophical trends then current in Germany. The demand that development government should enforce not merely formal but substantive, i.e., distributive or social justice, been advanced recently since the French Revolution. Toward the end of the 19th century, these ideas had already profoundly affected legal doctrine. By 1890, a leading socialist theorist of the law could thus express that was increasingly become the dominant doctrine by treating in a perfectly equal manner all citizens regardless of their personal qualities allowing unlimited competition between them. It came about that the production of goods was increased without limit, but the poor and weak had only a small share in the output. The new economic and social legislation therefore attempts to protect the weak against the strong and to secure for them a moderate share in the good things of life. This is because today it is understood that there is no greater injustice than to treat as equal what is in fact unequal. And there was Anatole France, who scoffed at the majestic equality of the law that forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread. This famous phrase has been repeated countless times by well meaning but unthinking people who did not understand that they were undermining the foundations of all impartial justice. Impartial, impartial, impartial. Impartial. Someone who is impartial is not directly involved in a particular situation and is therefore able to give a fair opinion or decision. The ascendancy of these political views was greatly assisted by the increasing influence of various theoretical conceptions which had arisen earlier in the century and which, though in many respects strongly opposed, had in common the dislike of any limitation of authority by rules of law and shared the desire to give the organized forces of government greater power to shape social relations, liberty, according to some ideal of social justice. The four chief movements which operated in this direction were, in descending order of importance, legal positivism, positivism, historicism, the free law school, and the school of jurisprudence of interest. We shall only briefly consider the last three before we turn to the first, which must detain us a little longer. The tradition which only later became known as jurisprudence of interest was a form of social similar to the legal realism of contemporary America. At least in its more radical forms, it wanted away from the kind of logical construction which is involved in the decision of disputes by the application of strict rules of law and to replace it by a direct assessment of the particular interests at stake in the concrete case. The free law school was in a way a parallel movement concerned mainly with criminal law. Its objective was to free the judge as far as possible from the shackles of fixed rules and permit him to decide individual cases mainly on the basis of his sense of justice. It has often been pointed out how much the latter in particular prepared the way for the arbitrariness of the totalitarian state. Historicism, historicism, which must be precisely defined so that it may be sharply distinguished from the greater historical schools in jurisprudence and elsewhere that preceded it, was a school that claimed to recognize necessary laws of historical development and to be able to derive from such inside knowledge of what institutions were appropriate to the existing situation. This view led to an extreme relativism, which claimed are the product of our own time and bound in a large measure by the views and ideas we have inherited, but that we can transcend those limitations and explicitly recognize how our present views are determined by circumstances and use this knowledge to remake our institutions in a manner appropriate to our time. Such a view would naturally lead to a rejection of all rules cannot be rationally justified or have not been deliberately designed to achieve a specific purpose. In this respect, historicism supports what we shall present see is the main legal positivism. Right.
Stoicism.
Historicism. Let's see how it. The belief that natural laws govern historical events, which in turn determine social and cultural phenomena. Wow. Natural laws govern historical events. Nat- The doctrine of legal positivism have been developed in direct opposition to a though it has for 2,000 years provided the framework within which the social problems have been mainly discussed. We have not explicitly considered. This is the conception of the law of nature, which to many still offers the answer to our most important question. We have so far deliberately avoided discussing our with references to this conception because the go under this name full of really different theories and an attempt to support them would require a separate book. But we must at least recognize here that these different schools of the law of nature have one point in common, which is that they address themselves to the same problem. But underlies the great conflict between the defenders of natural law and the legal positivists, positivists, positivists in is that while the former recognize the existence of that problem, the latter deny that it exists at all. At least that it has a legitimate place within the province of jurisprudence. Sort them out would require a separate book. Actually, the best brief survey of the different natural law traditions that I know of is Alessandro Passerini, Entero, Natural Law, An Introduction to Legal Philosophy, Hutchinson University Library, London. Book is the outcome of eight lectures delivered at the University of Chicago in April 1958. It may also be mentioned here that modern legal positivism derives largely from Thomas Hobbes and Rene Descartes. The 1971 German edition read 3 and includes Professor Bacon, men against whose rationalistic interpretation of society the evolutionary empiricist or Whig theology was developed, and that positivism gained its present day ascendance largely because ascendance ascendancy largely because of Hegel and Marx. For Marx's position, see the discussion of individual rights in the introduction to his the Karl Marx and Friedrich Engels historic Christian Gas Motul Work, Strove Brave, David Bors, Borisovic, Zanov, Berlin, Marx. And there are people, Hobbes, Descartes, and Bacon figures, right? Thomas Hobbes. And also Francis Bacon. So, historians. What are the school of natural law agree upon is the existence of rules, which are not of the deliberate making of any lawgiver. They agree that all positive law derives its validity from some rules that have not in the sense been made by men, but which can be found, and that these rules provide both for the justice of positive law and the ground for men's obedience to it, whether they seek the answer in divine inspiration or in the human reason, or in principles which are not themselves part of human reason, but constitute non-rational factors that grown the working of the human intellect, or whether they conceive of a natural law as permanent and immutable, or as variable in content. They all seek to answer a question which positivism does not recognize. For the latter, law, by definition, consists exclusively of deliberate demands of a human law. For this reason, legal positivism from the very beginning could have no sympathy with and no use for those meta-legal principles which underline the ideal of the rule of law, or the Rutstadt in the original meaning of this concept. For those principles which imply a limitation upon the power of legislation, in no other country ti- did this positivism gain such undisputed sway in the last century as it was consequently here that law was first deprived of real content, the substantive conception of the Protestant, which required that the rules of law possess definite properties, was displaced by a purely formal concept which required merely that all action of the state be authorized by the legislature. In short, a law was that which merely stated that wherever a certain authority should be, problem thus became mere legality, one of mere legality. By the turn of the century, it had become accepted doctrine that the individualist ideal of the substance vanquished by the creative powers of national and social ideas, or as an authority on administrative law described the situation shortly before the outbreak of the First World War. We have returned to the principles of the police to such an extent, again, recognize the idea of a closed state. The only difference is in the means. On the basis of laws, the modern state permits itself everything, much more than the police state did. Thus, in the course of the 19th century, the term Protestant was given a new meaning. We understand all activity takes place on the basis of laws and in legal form, on the purpose of the state and the limits of its com- competence. And term Protestant in its present meaning says nothing. Rechtsstaat. Are you kidding me? Rechtsstaat. 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 Don't you think it's amazing? Rechtsstaat. I don't think so. I think there's a word for it.何时醒来？何时醒来？It was, however, only after the First World War that these doctrines were given their most effective form and began to exert a great influence, which extended far beyond the limits of Germany. This new formulation, known as the pure theory of law and expounded by Professor H. Kelson, singled the definite eclipse of all traditions of limited government. His teaching was avidly taken up by all those reformers who had found the traditional limitation irritating obstacle to their ambitions and who wanted to sweep away all restrictions on the power of the
Avidly.
avidly. Whatever the flavor or color of your local paper, do remember that these are read avidly for local information in an avid manner.
Avid.
You use avid to describe someone who is very enthusiastic about something they do that they do. Wealth of nation, of nation here. Good. So Nelson himself had early observed how the fundamentally irretrievable liberty of the individual gradually recedes into the background and the liberty of the social collective occupies the front of the stage, and that this change in the conception of freedom meant an emancipation of democratic democratism from liberalism, emancipation of from liberalism, which he evidently welcomed. The basic conception of his system is the identification. The basic conception of his system is the identification of the state and the legal order. Thus, the predecessor becomes an extremely formal concept and an attribute of all states, even a despotic one. There are no possible limits to the power of the legislator, and there are no so-called fundamental liberties. Any attempt to deny to an arbitrary despotism the character of a legal order represents nothing but the naive and presumption of natural law thinking. Every effort is made not only to obscure the fundamental distinction between true laws in the substantive sense of abstract general laws, the merely formal sense of acts of legislation, but also to render indistinguishable from them the orders in the vague term norm. Even the distinction between jurisdiction and administrative acts is practically obliterated. In short, every single tenet of the traditional conception of the rule of law is represented as a metaphysical superstition. This logical, most consistent version of legal positivism illustrates by the 1920s had come to dominate German thinking and were rapidly spreading to the rest of the world. At the end of the decade, they had so completely conquered Germany that to be found guilty of adherence to natural law theories was a kind of social disgrace. The possibilities which this state of opinion created for an unlimited dictatorship were already clear, seen by acute observers at the time Hitler was trying to gain power. In 1930, a German legal scholar in a detailed study of the effects of the efforts to realize a socialist state opposite of the Rada state was able to point out that these doctrinal developments have already removed all obstacles to the disappearance of the Radestat rule of law and opened the doors to victory of the fascist and bourgeois will of the state. The increasing concern over these developments, which Hitler was finally to complete, was given expression by more than one speaker at a congress of German constitutional lawyers. But it was too late. The libertarian, the anti-libertarian forces had learned too well the the positive doctrine that the state must not be bound by law. In Hitler Germany and in fascist Italy, as well as in Russia, it came to be believed that under the rule of law, the state was unfree, a prisoner of the law, and that in order to act justly, it must be released from the fetters of abstract rules. A free state was to be treat its indispensable. The inseparability of personal freedom from the rule of law is shown most clearly by the absolute denial of the latter. But in theory, in the country where modern despotism have been carried furthest, the history of the development of legal theory in Russia during the early stages of communism, the ideals of still taken seriously, and the problem of the role of law in such a system was extensively discussed. It was instructed in their ruthless logic. The arguments advanced in the discussion show the nature of the problem more clearly than does the position taken by Western socialists, who usually try to have the best of both worlds. The Russian legal theorists deliberately continued in a direction which they recognized had long been established in Western Europe. One of them put it, the corruption of law itself was generally disappearing, and the center of gravity was shifting more and more from the passing of general norms to individual decisions and institutions which regulate, assist, and coordinate activities of administration. Or as another tendon at the same time, since it is not possible to distinguish between laws and administrative regulations, this contrast is a mere fiction of bourgeoisie theory and practice. The best description of these developments we owe to a non-communist Russian who observed that what distinguishes the Soviet system from all other despotic government is that it represents an attempt to found the state principles which are the opposite of those of the rule of law. And it has evolved a theory which exempts the rulers from every obligation or limitation, as the communist theorists expressed it, the fundamental principle of our legislation and our private law, which the bourgeoisie will never recognize as everything is prohibited, not simply permitted. What a sore ball. Finally, the communist attacks came to be directed at the conception of law itself. 1927, Court explained in the official handbook of private law, communism means not the victory of socialist law, but the victory of socialism over any law. Since with the abolition of classes which antagonistic interests, law will disappear altogether. For this stage of the development were most clearly explained by the legal theories. E. Peshu, whose work for a time, whose work for a time, whose work for a time attracted much attention both inside and outside Russia, but who later fell from disgrace and disappeared. He wrote, to the administrative technical direction by subordination to a general economic plan for methods of direct, technologically determined direction in the shape of programs for production and distribution. Gradual victory of this tendency means the gradual extinction of law as such. In short, as in a socialist community, there was no scope for autonomous private legal relations, but only for regulation in the interest of the community. All law was converted into administration, all fixed rules into discretion and utility. In England, developments away from the rule of law had started early, but for a long time remained confined to the sphere of practice and received a little theoretical attention, though by 1915 Dicey could observe that the ancient veneration for the rule of law has in England suffered during the last 30 years a marked decline. The infringements of the principle attached attracted little notice. In the ninth book called The New Justice, pointed out how little in accord with the ru- rule of law has the situation which had developed. It achieved the scandal, but to change the place safely protected by the tradition. The book was treated as a mere reactionary pamphlet, which was directed at it. It's difficult to understand a quarter of a century later, when not only liberal organs like the Economist, but also socialist authors have come to speak of the danger in the same terms. The book did indeed lead to the appointment of an official minister's powers, but its report, while mildly reasserting Dicey's doctrines, tended on the whole minimize the dangers. It may its main effect was that it made the opposition to the rule of law articulate and evoked. an extensive literature which outlined an law doctrine which has since come to be accepted by many besides socialists. This movement has led by a group of socialist lawyers and political scientists gathered around the late Professor Harold attack was opened by attack was opened by Dr. Jennings. These reviewed of the report and the documents on which the letter was based, completely accepting the newly fashionable positivist doctrine. He argued that the conception of the rule of law, in the sense in which it was used in that report, is that equality before ordinary law of the land, administrative by the ordinary courts, taken literally, is just nonsense. This rule of law, he contended, is either common all nations or does not exist. No, he had to concede that the 15th century certainty, the fixity and certainty of the law have been part of the English tradition for centuries. It so only was evident impatience at the fact that this tradition but reluctantly broken down. The belief shared by most of the members of the community and most of the witnesses that there was a clear distinction between the functions of a judge and the functions of an administrator. Dr. Jennings had only later expounded these views in a widely used textbook in which he expressly denied that the rule of law and discretionary powers are contradictory, or that there is any opposition between regular law and administrative powers. The principle in Dicey's sense, namely, the public authority ought not to have wide discretionary powers, was a rule of action for which it may be ignored by others. Though Dr. Jennings recognized that a constitutional lawyer of 1870 or even 1880, it might have seemed that the British Constitution was essentially based on the individualist rule of law, and that the British state was the resident of individualist political and legal theory. This meant to him merely that the Constitution frowned on discretionary powers they were exercised by judges. When Dicey said that Englishmen are ruled by the law and by the law only, he meant that Englishmen are ruled by judges and by judges alone. That would have been an exaggeration, but it was good individualism. That it was a necessary consequence of the ideal of liberty under the law, that only experts in the law and no other experts, and especially no administrators concerned with particular aims, should be entitled to order coercive action seems not to have occurred to the author. should be added that further experience and appearance appears to have led Sir Ivor to modify his views considerably. He begins and concludes a recent popular book with section in praise of the rule of law and even gives a somewhat idealized picture of the degree which it still prevails. But this change, not for his attacks, had a effect. In a popular vocabulary of politics, for instance, which had appeared in the same series only a year before the book just mentioned, we found it argued that it is therefore odd that there should be a prevalent view that the rule of law is something which some people have but other people not, like motor cars and telephones. What does it mean then to be without them? I fear this question correctly represents the position of most of the younger generation, grown up under the exclusive influence of positivist teaching. Equally important and influential has been the treatment of the rule of law in a wider used treatise by another member of the same group, Professor W. A. Robson. His discussion combines a commendable zeal for regularizing the chaotic state of the control over administrative action with an interpretation of the task of administrative tribunal, which, if applied, would make them entirely ineffective as a means of protecting individual liberty. He aims explicitly at accelerating the breakaway from that rule of law which the late Professor A.V. Dicey regarded as an essential feature of the English constitutional system. Argument commences with an attack on that antique and rickety chariot, the legendary separation of powers. The whole distinction between law and policy is to him utterly false. And the conception that the judge is not concerned with governmental ends but with the administrative of justice a matter for ridicule. He even represents as one of the main advantages of administrative tribunals that they can enforce a policy unhampered by law and judicial precedents. Of all the characteristics of administrative law, none is more advantageous when rightly used for the public good than the power of the tribunal to decide the cases coming before it with the avowed object of furthering a policy of social improvement in some particular field and of adapting their attitude towards the controversy so as to fit the needs of that policy. Few other discussions of these problems show as clearly how reactionary many of the progressive ideas of our time really are. It is therefore not too surprising that such a view as Professor Robson's has rapidly found favor with the conservative and that a recent conservative party the rule of law echoes him in commending administrative tribunals for the fact that fixable and unbound by rules of law or precedent, they can be of real assistance to their minister in carrying out his policy. This acceptance of social doctrine by the controversial conservatives is perhaps the most alarming feature of the development. It has gone so far that it could be said of a conservative symposium on liberty in the modern state. So far, have we traveled from the English from the risk of opposition by the government or its servants that no one of suggests that it would now be possible for us to go back to that 19th century idea where is shown read statements of some of the less well known members of that group of socialist lawyers. One commences an essay on the planned state and the rule of law by redefining the rule of law. It emerges from the only as whatever parliament as the supreme lawgiver makes it. Uh,
Mauling.
Mauling. If you are mauled by an animal, you are violently attacked by it and badly injured. Maul. Mauling. This enabled the author to assert with confidence that the incompatibility of planning with the rule of law, first suggested by socialist authors, is a myth sustainable only by sheer prejudice or ignorance. Another member of the same group even finds it possible to reply to the question as to whether, if Hitler had obtained power in a constitutional manner, the rule of law would still have prevailed in Nazi Germany. The answer is yes. The majority would be right in operation. If the majority voted him into power, the majority might be unwise and it might be wicked, but the rule of law would prevail. For in a democracy, right is what the majority makes it to be. Here we have the most fatal argument expressed in the most uncompromising terms. It is not surprising then under the influence of such conceptions, there has been in Great Britain during the last 2 or 3 decades a rapid growth of very imperfectly checked powers of administrative agencies over the private life and property of the citizen. The new social and economic legislation has conferred ever increasing discretionary powers on those bodies and has provided only occasional and defective remedies in the form of a madly tribunals of committees for appeal. In extreme instances, the law has even gone so far as to give administrative agencies the power to determine the general principles whereby what amounted to expropriation, expropriation, expropriation,
Expropriation.
expropriation, whereby what amounted to expropriation could be applied. The executive authority tie itself down by any especially after instance of high-handed bureaucratic action was brought to the attention of the public by the persistent efforts of a wealthy and public spirited man. Has the disquiet over these developments long left by a few informed observers spread to wider circle and produced the first signs of a reaction, which we shall refer later. It is somewhat surprising to find that in many respects developments in this direction have gone hardly less far in the United States. In fact, both the modern trends in legal theory and the conception of the expert administrator without legal training have had an even greater influence here than in many, even it may even be said that the British socialist lawyers we have just considered their inspiration more often in American than in Britain legal philosophers. The circumstances which have brought this about are little understood even in the United States and they deserve to be better known. The United States is, in fact, unique in that the stimulation received from crystallized into what come to be known significantly as the public administration. It played a role somewhat similar to that of the Fabian movement in Britain or of the socialist of the chair movement in Germany. Its efficiency in government as its watchword was skillfully designed to enlist the support of the business community for basically socialist members sympathetic support of the progressives directed their heaviest attack against a traditional safeguard of individual liberty, such as the rule of law, constitutional restraints, judicial review, and the conception of a fundamental law. It was characteristic of these experts in administration. They were equally antagonistic and commonly largely ignorant of both law and economics. In their effort to create a science of administration, they were guided by a rather naive conception of scientific procedure and showed all the contempt characteristic of the constrained rationalist. It was they who did most to popularize the idea that liberty for liberty's sake is clearly a meaningless notion. It must be liberty to do any something. If more people are buying automobiles and taking vacations, there is more liberty.
Antagonistic.
If a person is antagonistic to someone or something, they show hatred or dislike towards antagonistic, equally antagonistic approach. It was mainly because of their effort that constitutional European conception of administrative powers were introduced to the United States rather early than in England. Thus, as early as 1920, one of the most distinguished American students of jurisprudence could speak of a tendency away from courts and law and a reversion to justice without law in the form of revival of executive and even of legislative justice and reliance upon arbitrary governmental power. A few years later, a standard work on administrative law could already represent it as accepted doctrine that every public officer has marked out for him Within the boundaries of that area, he can act freely according to his own assertion, and the courts will respect his action as final and not inquire into its rightfulness. But if he oversteps those bounds, then the court will intervene. In this form, the law of court review of the acts of public officers forms simply a branch of the law of ultra, ultravirus. Ultravirus. The only question before the courts is one of jurisdiction, and the court has no control of the officers' exercise of discretion within that jurisdiction. The reaction against the tradition of stringent control of the courts over not only administrative but also legislative action had, in fact, commenced sometime before the First stringent
Stringent.
as an issue of practical politics. It became important for the first time in Senator Law Follett's campaign for the presidency in 1924, when he made the curbing of the power of the courts an important part of his platform. It is mainly because of this tradition which the senator established that in the United States more than elsewhere, the progressives have become the main advocates of the extension of the discretionary powers of the administrative agency. By the end of the 1930s, this characteristic of the American progressives had become first faced with the dispute with the American liberals and the American conservatives concerning the question of administrative law and administrative version were inclined to warn them against the inherent dangers of the rise of administrative desertion, and to tell them that we, i.e., the European socialists, could vouch for the truth of the stand of the American conservative, but they were soon when they attitude of the progressive facilitated the gradual and unnoticed movement of the American system towards socialism. The conflict referred to above reached its climax, of course, during the Roosevelt era. The way had already been prepared for the developments of that time by the intellectual trends of the preceding decades. The 1920s, early 1930s had seen a flood of anti-rule of law literature, which had considered able influence the later developments. Mention here only two characteristic examples. One of the most active of those who led the frontal attack on the American tradition of the government of law and not of men was Professor Charles G. Bennett, who not only represented the traditional ideal as an illusion, but seriously pleaded that people should establish governments, theory of trust in man affairs. To realize how completely this is in a conflict with the whole conception underlying one statement that free government is founded in jealousy, not in confidence. It is jealousy and not confidence which prescribes limited constitutions to bind those we are obliged to trust with power. Our Constitution has accordingly fixed the limits to which, and no further, our confidence may go. In questions of power, then, let no more be heard of confidence in men, but bind him down from mischief by the chains of the Constitution. Perhaps even more intellectual tendencies of the time is work by the late Justice Jerome Frank, called The Laws and the Modern Mind, which, when it first appeared in 1930, enjoyed a success which, for the reader of today, is not quite easy to understand. It constitutes a violent attack on the whole idea of which the author ridicules as the product of a childish need for an authoritative father, basing itself on psychologically psychoanalytic psychoanalytic theory. The work supplied by the kind of jurisdiction for a contempt for a traditional ideals that a generation ought to accept any limitation on collective action. It was the young men brought up on such ideas who become the ready instruments of the per, paternalistic, per, pater- paternalistic policy of the New Deal. Toward the end of the 1930s, there was increasing uneasiness over these developments, which led to the point of a committee of investigation, U.S. Attorney General's Committee on Administrative Procedure, whose task was similar to that of the British Committee of 10 years earlier, but this too even more than the British Committee tended in its majority report to represent what was happening as both inevitable and harmless. The general tenor of the report is best described in the words of D. Russell. Even if quite unintended, the majority of the in mind of administrative, which is a phase of the rise throughout the world. Ideas of the disappearance of law, of a society in which there will be no law, or only one law, namely that there are no laws but only administrative orders, utterance that there are no such things as rights, and that laws are only threats of exercise of state force, principles being nothing but superstition and pious wish. A teaching that separation of powers is an outmoded, out, outmoded 18th century fashion of thought. Common law doctrine of the of law had been outgrown and expounding of a public law which is to be a subordinating law, subordinating the interests of the individual to those of the public official, and allowing the latter to identify one side of a controversy, public interest, and so give it a greater value and ignore the others. And finally, the theory that law is whatever is not officially, and so whatever is not officially is law, and beyond criticism by lawyers. Such is the setting in which the proposals of the majority must be seen. Perhaps most suspicious in the countries that have gone through the experience of totalitarian regimes and have understood the dangers of relaxing the limits the limits of the state. Even among those socialists who not long had nothing but safeguards liberty, a such more respectful attitude can be observed. Few men have so frankly expressed this change of view as the distinguished dean of socialist legal philosophers, the late Gustav Rudbridge, who, in one of his last works, said, "Though democracy is certainly a praiseworthy virtue, the rudderstadt is like the daily bread, the water we drink and the air we breathe, and the merits of democracy is adopted to preserve the rule of state. That democracy does not, in fact, necessarily or invariably do so is only too clear from Redford's description of developments in it would probably be truer to say that democracy will not exist long unless it preserves the rule of law. The advance of the principle of judicial review since and the revival of the interest in other continental countries, similar movements are underway. In France, has made significant contribution with his study of the decline of law, in which he rightly concludes that above all we must put the blame on the jurists. It was they who, for half a century, undermined the conception of individual rights without being aware that they thereby delivered rights to the omnipotence of the political state. Some of them wish to themselves progressive, while others believe that they were rediscovering traditional doctrine which the liberal individualism of the 19th century had obliterated. Scholars often show a certain single-mindedness which prevents them from seeing the particular conclusions which others will draw from their distinct disinterested. There has been similar voting voices in Great Britain, and the first outcome of the increasing apprehension has been a renewed tendency in recent legislation to restore the courts of law as the final authority in administrative disputes. Encouraging signs are also to be found in a recent report of the Committee of Inquiry into Procedure for Appeals to other than ordinary courts. In it, the committee not only made important suggestions for eliminating the numerous anomalies anomalies and defects of the existing system, but also admirably reaffirmed the basic distinction between its antithesis being what is administrative and the notion of what is according to the rule of law, his antithesis being what is arbitrary. It then went on to state the rule of law stands on the view that decisions should be made by known principles or laws. In general, such decisions will be predictable, and the citizen will know there still remains in Britain a considerable field of administration in which no special tribunal or inquiry is provided, which problem was outside the terms of reference of the committee, and where the conditions remain as unsatisfactory as ever, and the citizen, in fact, is still at the mercy of an arbitrary administrative decision. If the process of erosion of the rule of law is to be halted, there seems to be urgent need for some
Anomalies. Antithesis.
the antithesis of something is exact
Antithesis.
antithesis. What But there still remains in Britain a considerable field of administration in which no special tribunal or inquiry is provided, which problem was outside the terms of references of the committee, and where the conditions remain as unsatisfactory as ever, and the citizen in effect is still at the mercy of an arbitrary administrative decision. If the process of erosion of the rule of law is to be halted, there seems to be urgent need for some independent court to which appeal lies in all such cases as from several quarters. Finally, we might mention as an effort on an international scale the Act of Amnesty, adopted in June 1955, had Congress the International Commission of Jurists, in which the importance of the rule of law is strongly reaffirmed. It can hardly be said, however, that the widespread desire to revive an old tradition is accompanied by a clear awareness of what this would involve, or that people would be prepared to uphold the principles of this tradition even when they are obstacles in the most direct and obvious route. Some these which not long ago seemed commonplaces hardly worth restating, and which perhaps even today will seem more obvious to the layman than to the contemporary lawyer, have been so that a detailed account of their history and their character seemed necessary. It is only on this basis that we can attempt in the next part to examine is examine more the different ways in which the various moderations of economic and social policy cannot be achieved within the framework of a free society.
Layman.
Layman. Okay, we just finished chapter 6 of Fred Hayek. And the name of the chapter is The Decline of Law, Decline of Laws. And actually, there's a book called The Decline of Laws. Translation, I believe, is